What is the International Court of Justice? That's what I'm going to cover in today's video. The International Court of Justice is an international court based in The Hague in the Netherlands. It deals with legal disputes between states. This involves a wide variety of substantive issues such as border disputes, disputes over the interpretation of international treaties, or disputes over military activities. In short, all kinds of conflicts between states in the field of international law. In addition, the International Court of Justice also renders advisory opinions on questions of international law in certain cases. The International Court of Justice is also referred to as the World Court. The International Court of Justice goes back to the Permanent Court of International Justice. The Permanent Court of International Justice was established in the early 1920s. Its task was to decide disputes between states in a way that was binding under international law. Arbitration courts for disputes between states had already existed before the First World War. However, these had the disadvantage that there were no judges who carried out this task on a permanent basis. Rather, the courts were composed as needed. Therefore, no long-term jurisprudence could emerge. After the First World War, the political will to find instruments to resolve disputes between states in a peaceful manner intensified. One of the steps towards this was the founding of the League of Nations. The League of Nations was an association of states which had the aim of maintaining peace through disarmament, a system of collective security, and the orderly settlement of international conflicts. To achieve the goal of an orderly settlement of international conflicts, the League of Nations drafted a set of rules for a court that would deal with conflicts between states. The Permanent International Court of Justice. The Permanent International Court of Justice began its work in 1922. It could hand down legally binding decisions in disputes between states. The Second World War brought the end of the League of Nations, and the work of the Permanent International Court of Justice came to a halt. After the Second World War, the United Nations were founded. There was a discussion about bringing the Permanent International Court of Justice back into existence. However, the statute of the Permanent International Court of Justice had proved to be inflexible in some regards. Therefore, it was decided to establish a new court to perform the same functions. This was the International Court of Justice. Its statute varies in detail from the one of the Permanent International Court of Justice, but the basic concept is the same. The International Court of Justice is closely linked to the United Nations. The United Nations Charter refers to it as a principal judicial organ of the United Nations. Basically, the International Court of Justice deals with contentious proceedings and with issuing advisory opinions. In contentious proceedings, the International Court of Justice deals with conflicts between states. Only states can be parties to such proceedings. There is therefore no possibility for individuals to lodge an application or to initiate proceedings, as it is the case with the ECHR, European Court of Human Rights, for example. The International Court of Justice also does not deal with the prosecution of individuals, as the International Criminal Court does. Therefore, it cannot convict a person. It deals exclusively with questions and conflicts between states. The International Court of Justice renders a judgment regarding the dispute, and this judgment is binding on the states. The prerequisite for this, however, is that the states have submitted to the jurisdiction of the court. This follows from the sovereignty of states. Since states are sovereign, international courts or institutions can only make decisions about them if the states have declared their agreement, in principle. To clarify, of course, that does not mean that states have to give their consent to a judgment in a specific case after the fact. Rather, states must declare in principle that they submit to the judgments of the International Court of Justice. This declaration can take several forms. First, states can make a declaration that they submit in principle to the jurisdiction of the International Court of Justice. This declaration then applies to disputes with any other state that has made the same declaration. State A thus declares that it accepts the jurisdiction. State B declares the same. If a conflict arises between State A and State B, the International Court of Justice has jurisdiction. So far, 73 states have made such a declaration, including Germany, Switzerland, and Austria. The second possibility is for states to declare that the International Court of Justice should have jurisdiction to decide a conflict after a conflict has arisen. For example, State A has a dispute with State B over territorial claims. Both states declare that the International Court of Justice should rule on this conflict. This usually takes the form of a mutual declaration. In addition, there are many international treaties and agreements that expressly provide that the International Court of Justice has jurisdiction over disputes arising from the treaty. One example is the United Nations Convention Against Corruption. It obliges states to take certain measures to combat corruption. For example, to enact certain laws, to confiscate assets, and so on. Section 66 states that all disputes between two or more states concerning the interpretation of the Convention shall first be submitted to arbitration, and if this does not lead to a result, that the International Court of Justice shall have jurisdiction. Finally, there is the possibility that the jurisdiction of the International Court of Justice is established by the fact that a state against which a case is directed participates in a proceeding in a specific case. This means that the International Court of Justice normally would not have jurisdiction. Nevertheless, one state sets the proceedings in motion and the other state indicates that it agrees to continue the proceedings. One example is the case certain criminal proceedings in France, a case brought by the Republic of Congo against France. Various human rights organizations had filed criminal charges against the President of the Republic of Congo, the Minister of the Interior of the Republic of Congo, and other high officials. The criminal complaints concerned allegations of torture and crimes against humanity. The French authorities then initiated criminal proceedings. The Republic of Congo filed an application with the International Court of Justice to begin proceedings. It argued that the prosecution violated the principle of sovereignty of state and state immunity. However, France had not submitted in principle to the jurisdiction of the International Court of Justice. There was no express agreement for this case either. Therefore, the International Court of Justice normally would not have had jurisdiction. The Republic of Congo therefore wrote in its application that it assumed that France would consent to the proceedings. And France actually did so, writing to the International Court of Justice, "We agree that these proceedings should be conducted." So that is another way in which the jurisdiction of the court can be established. In addition to contentious proceedings, the International Court of Justice has jurisdiction to give advisory opinions. Certain international organizations can apply to the International Court of Justice for an advisory opinion on legal questions. The United Nations Charter states that the United Nations General Assembly or the Security Council may request an opinion from the International Court of Justice on any question of law. In addition, the General Assembly may also authorize other organs of the United Nations or specialized agencies to request legal opinions. These are, for example, the World Health Organization, the International Labour Organization, or UNESCO. The International Court of Justice has 15 permanent judges. These judges are elected for a term of 9 years. They are elected by the General Assembly and the United Nations Security Council. The aim is to ensure that not only the judges are qualified, but also that they represent important legal systems and civilizations of the world. In addition to that, there are ad hoc judges in some proceedings. If states are involved in a proceeding that do not have a judge of their nationality, the respective country may appoint an ad hoc judge.